Good morning, everyone. Sorry for the delay. We've just had a few technical difficulties, but I think we're working through those, so we should be able to get started. My name is Scott Treader. I'm a program manager here in the Department of Consumer and Business Affairs Housing and Tenant Protections Unit. I will be sharing an update today on tenant protections in LA County. I'm also joined by my colleague, George Serta, who will also be sharing additional information out as well a little bit later in the presentation. So next slide, please. Okay, again, my apologies, just a few technical difficulties, but we're good to get started. So again, my name is Scott Treader. I am program manager here with the Department of Consumer and Business Affairs, and we will go ahead and get started on what we'll cover today. Okay, so we'll be giving a brief introduction on the Housing and Tenant Protections Division and what's under our purview, an update on the status of the county's Emergency Tenant Protections Resolution. Then we'll share what permanent tenant protections currently exist in the county. We will also discuss the upcoming expiration of the emergency tenant protections, and then also review available resources for tenants. And then lastly, we'll have some time at the end of the webinar to entertain questions, okay? Next slide, please. A little bit about the Housing and Tenant Protections Division. The Department of Consumer and Business Affairs has worked in the space of landlord-tenant assistant for a number of years, but the team was formed officially in 2018 to implement board initiatives aimed to protect vulnerable tenants in the county. The division oversees and enforces the county's two rent stabilization ordinances. One is for brick and mortar rental units, and the other ordinance applies to space rent in mobile home parks in unincorporated LA County. Our division also supports the Rental Housing Oversight Commission, which serves as the appellate body for our staff decisions. As a result of the COVID-19 pandemic, our division had to pivot to also implement the county's emergency COVID-19 tenant protections. This was formerly known as the eviction moratorium. Our division also oversees and administers the Stay Housed LA County program. This is the county's branded eviction defense program. Next slide, please. Next, I'd like to provide an update on the status of the county's COVID-19 protections. I'd like to recognize that these protections have evolved over time and have given all the jurisdictions in LA County and federal and state protections were also implemented during the pandemic. We know this is confusing, so there are these multiple layers of protections at various levels of government, and we'll try and help you sort through that today because we know it is confusing. Our goal is to provide you with a high-level overview of what's in place for the county now, what will be expiring at the end of the day tomorrow, and then what protections will continue on beyond. So literally our protections for the tenant protections resolution, the temporary protections, they will be expiring at the end of the day tomorrow, March 31st. But again, as I mentioned, there are a few protections that will extend beyond March 2023 that are still part of that resolution. Next slide, please. So what is the county's COVID-19 tenant protections resolution? It went into effect March 4th, 2020 at the beginning of the pandemic, and those protections do run through March 31st, 2023. What the protection did was place a countywide ban on most evictions for residential tenants And this included mobile home space renters who were impacted by COVID financially. There were protections for commercial tenancies, but those protections did expire last year. But we did want to mention that the resolution did provide certain protections for those tenants as well. The county's tenant protections resolution applies to all of unincorporated LA County, as well as incorporated cities within the county. This is to ensure that there was a baseline of protections for all residents. These protections apply if the local protections were non-existent, or if the local protections in various cities did not provide as much protection as the county's tenant protections resolution. Next slide, please. And while those protections are set to expire soon, we did want to take a moment to discuss what is currently in place through the end of this month, literally in effect until end of the day tomorrow, as I said. Residential tenants and mobile home space renters are protected against evictions due to non-payment of rent, due to being financially affected by COVID-19 from the period July 1, 2022 through March 31, 2023. Income qualified tenants are required to provide notice to their landlords if they were financially impacted by COVID, and they were required to provide that notice or certification to the landlord within 7 days of the rent being due. It's important to note that the county's resolution was never a cancellation rent. It was merely just a protection to temporarily help people that were having trouble either with their employment or with their income, just to ensure that they weren't evicted unnecessarily. But the tenants have always been required to pay back the unpaid rent. The protections also provided no fault protections for tenants, meaning that tenants couldn't just be evicted for any reason. If the landlord wanted to evict the tenant, there had to be a reason, or an at-fault reason. The tenant did something wrong, they were at fault. That would be a reason a tenant could still be evicted. Otherwise, if the landlord just wanted a tenant out, these protections prevented that from happening, or provided an affirmative defense to the tenants. If they were to go to court, a tenant could assert those rights in court as a defense against an eviction. The protections also provided protections for nuisance and also unauthorized occupants or pets who began residing in a unit between the period of March 1, 2020 and January 20, 2023. Next slide, please. So what happens after tomorrow, March 31st? What protections survived the resolution? For tenants who did use the county's non-payment of rent protections between that period, July 2022 and March 31st, 2023, those tenants will still be protected against eviction for no-fault eviction reasons. Again, meaning that the tenant didn't do anything wrong, the tenant wasn't at fault, the landlord is just trying to evict that tenant. Although there is an exception for certain qualified owner move-ins. The protections against harassment and retaliation are still in effect through the protection periods. Starting April 1, 2023, landlords are required to serve tenants with a written 30-day notice prior to filing an eviction or an unlawful detainer based on non-payment of rent for rent accrued during the protected period. For tenants who have unauthorized occupants or pets in their units who began residing in the units between March 2020 and January 2023, those protections are still in place. Starting April 1, 2023, Again, landlords are required to serve a written 30-day notice prior to filing an eviction or unlawful detainer based on the presence of unauthorized occupants or pets. Next slide, please. As mentioned previously, the emergency protections are set to expire at the end of the day tomorrow, March 31st. We just want to recap that on February 28th, 2023, the Los Angeles County Board of Supervisors voted to end the local emergency declared relating to COVID. And that also marked the end of the county's tenant protections resolution, which does expire at the end of the day tomorrow. Next slide, please. And while we discuss the protections that survived the resolution, we did want to take a moment just to highlight what that actually means, what the expiration of these tenant protections means. Most evictions for residential tenants and mobile home space renters may resume as normal, except for no-fault evictions for tenants who exercised the county's non-payment of rent protections during the protected period. Tenants must resume making rent payments as normal to avoid being evicted effective as of April 1st, because as of April 1st, 2023, there will no longer be non-payment of rent protections in place for tenants. Very important. Tenants who utilize the county's non-payment of rent protections still have 12 months to repay the past due rent. What that means is, for example, if a tenant was unable to pay their rent for July 2022, then they would have a 12-month repayment period, which would begin on August 1, 2022, and run through 12 months at the end of July 31st, 2022, or 2023, I'm sorry. Another example is if a tenant was unable to pay rent for August 2022, the repayment period would begin the following month, September 1, 2022, and run for a 12-month period through August 31st, 2023. Rent increases beginning April 1st will also be issued now for rent stabilized units and mobile home spaces in unincorporated LA County. This is in accordance with the county's rent stabilization and tenant protection ordinances. There will be a 3% cap in effect for the 2023 calendar year, and luxury units are capped at a higher percentage at 5%. So just to repeat, because this is something we get a lot of questions on, how much can rent be increased in unincorporated LA County? For a fully covered rent stabilized unit in unincorporated LA County, the rent increases are capped at 3% beginning on April 1, beginning on the day after tomorrow. While the tenant protections are expiring, there are still some permanent protections that are in place for unincorporated LA County and certain incorporated cities. It's important that you verify the jurisdiction of the rental property that you are renting to ensure that you are up to date with any permanent protections that may apply to you and to that rental property. I'm now joined by George Serta, who will be presenting more information on the permanent protections under the Rent Stabilization Ordinance. So I will turn it over to him at this point.
Thank you very much, Scott. Hi, everyone. My name is George Serta, and I work as part of the county's Rent Stabilization Enforcement Program. I want to first start out by expanding upon a concept that Scott touched upon in his portion of the presentation, and that is the difference between the incorporated cities that we have here within the county and the unincorporated areas. So this is something that a lot of us, who have lived in Los Angeles our whole lives may not be familiar with, But within the county of Los Angeles, we have 88 cities. And under normal circumstances, cities like the city of Los Angeles, Glendale, Burbank, Pasadena, et cetera, Long Beach, they can all set their own protections, their own laws. And the residents of those cities follow the lead of their own city. It was under the pandemic that the Board of Supervisors, who oversees the county, had emergency powers where they could expand their rule of law to cities that didn't have their own protections. Now, the portion that I'm going to be covering now is specific to the unincorporated areas. So those portions that are not part of one of those 88 cities. Now, how can someone find out if they're living in the unincorporated area? Well, we're going to share a resource with everyone with the Registrar Recorder's Office, where someone can put in the address of the property they're living in, and it will bring up the jurisdiction to explain if you're living in an unincorporated area. Okay, next slide. Okay, so we're going to be going into the Rent Stabilization and Tenant Protections Ordinance. We refer to it using the acronym the RSTPO. This ordinance is fairly new. It's the county's version of rent control. It's fairly new compared to some of the other rent controls that have been around under, for instance, the city of Los Angeles, Beverly Hills, West Hollywood, Santa Monica, where those have been around for many, many decades. Ours has only been around since going back to 2018. So we do have many tenants and many landlords who do not yet understand that their property may be under these rules. And we also get many landlords and attorneys who may confuse our rules with the rules in place for, let's say, the city of Los Angeles. So it's important to understand the difference that we have. These rules existed prior to the pandemic. They continued on through the pandemic. They were strengthened under the rules that were adopted by the board during the pandemic, and they're going to continue on. They get updated about every year or so to close loopholes, to strengthen protections, but we're going to share with you what the general guidelines are, rules are, as they stand right now. So the first thing to understand is the RSTPO limits annual rent increases. It protects tenants from evictions without a just cause, meaning it requires a reason, a legal reason that we outline. It requires relocation assistance in the event that the tenant has not done something wrong, or they are being temporarily displaced, perhaps due to a repair. It protects tenants from retaliatory evictions and harassment. It requires landlords to register their units annually with the county. It allows landlords to receive a fair return on their properties and pass through certain costs to tenants. And it prohibits increases in security deposits. Next slide. So we have two levels of protections within our ordinance. Those units that are considered fully covered and those that are considered partially covered. And this refers to all of the rental units located in the unincorporated areas of the county. So in order to be fully covered, a unit will have to be located in the unincorporated, on a lot with two or more, a parcel, a lot with two or more rental units, and that includes illegal units. We count illegal units as part of that calculation. And the dwelling has to have a certificate of occupancy or equivalent permit issued on or before February 1st of 1995. And that has to do with the Costa-Hawkins cutoff that the state has in place, where local rent control can't regulate units that were built younger than that date, after that date. Partially covered units, in order to be partially covered, it just has to be located in the unincorporated area of LA County. And this may capture all of those other types of units where they're not multi-dwelling, including single-family homes or condos. Next slide. Okay, let's talk about permitted rent increases for fully covered units under the RSTPO. Rent increases for this year, as Scott talked about, are capped at 3%. Or 5% for luxury units. The definition of a luxury unit is specific under our ordinance, so it's not just, hey, your unit is nice. So look to our definition within our ordinance if you think you might be living in what's considered a luxury unit. So that'll be, again, till the end of this year. Normally, our rent increases are tied to the consumer price index. We're on a delay compared to other rent control ordinances, but normally this would be tied to changes in the consumer price index. A rent increase can only happen once in a 12-month period. No rent banking is allowed, so that means if a property owner, for instance, didn't do a 3% increase this year, they couldn't then next year add that 3% to an increase then. So it's a use it or lose it situation. The absolute cap within our ordinance is 8% in any given year. So if CPI, like it is now, was very high, exceeding 10% in some instances, our cap will still be at 8%. We do have a 10% cap for luxury units, but that's going to expire at the end of this year, where everyone will be under the same cap. This also includes any pass-throughs unless otherwise determined by DCBA. And the other important thing to understand, this is a relatively new addition to our ordinance, is that the addition of occupants does not authorize a rent increase or an increase in security deposit. Next slide. Actually, Mary, can we go back to the previous slide? I forgot to mention here, so understanding base rent, where do our calculations begin from? So if you've been living in your unit since before September 11, 2018, we start with what you were paying on September 11, 2018 to do these calculations. It just so happened that in the years between September 11, 2018 and March 3rd, 2020, before the rent freeze went into effect, that rent increases were tied to CPI, and CPI was 3% at that time. If you moved in after September 11, 2018, it's the rent that you were paying when you moved in. That's where we will start our calculations. Thank you, Mary. Next slide. Okay, just cause eviction. So we have two types of allowable evictions under our ordinance. The first is at fault. So this is where the tenant has done something wrong. So they include things like a failure to pay rent. However, the added protection here is that we require that the tenant owe an amount exceeding a threshold. And for us, that threshold is the equivalent of 1 month of fair market rent as calculated by HUD. HUD updates those amounts every year. So we will look to make sure that the tenant owes, or I should say, the tenant should not be facing an eviction if that threshold has not been exceeded in terms of debt owed. The next possible option might be a violation of material terms of the rental agreement. Again, our ordinance does exclude certain actions from what's considered a material term, such as adding additional occupants to the unit that aren't authorized, being a nuisance, or using the unit for an illegal purpose, failure to sign a substantially similar lease, meaning this is again expanded on within our ordinance. If a tenant's 1-year lease is up 90 days before the lease is up, the landlord can require them to sign a new lease so long as the terms are identical to the existing lease. They can't change something. That includes a rent increase that would be above the allowable. Failure to vacate as required by an approved relocation application with the county. So if they meet one of our no fault eviction allowable instances, as I'll explain later, and they've paid the relocation to you as required by our ordinance and you still remain there, then they can move forward with an at-fault eviction. And then finally, if you're within a household that has, a housing situation that has government regulated income limits and you exceed those limits, that may also be an at-fault reason to proceed with an eviction. Some of the no-fault reasons. So all of these require a process that the county has in place, and they also require that the tenant be paid permanent relocation. That would include things like a landlord or landlord's qualified family member moving into the unit, the withdrawal of the units from the rental market, meaning this unit will not be rented for at least 10 years, or a government agency or court order. Perhaps maybe the unit is unpermitted and the county has, or some agency has determined that it needs to be reverted back to its previous use. In that situation as well, the tenant could be evicted, but they would have to be provided with permanent relocation assistance. One comment that I want to make here that I often hear from landlords is that they will confuse that just because a tenant is now into the month-to-month portion of their lease, that they can evict a tenant at will. So I just want to make it clear that that is not the case under our protections. Now that you're in the month-to-month period, these protections would still apply to the tenant. The only thing that changes is now a tenant can voluntarily vacate with a 30-day notice or whatever notice is required as part of your lease. Next slide, Mary. Okay, the county also has a separate ordinance that covers mobile homes located in the unincorporated areas of LA County. It limits annual rent increases. It allows mobile home park owners to receive a fair return and pass through certain costs to mobile homeowners. It requires park owners to register their spaces annually, and it protects against retaliatory eviction and anti-harassment. In order to qualify under our mobile home rent stabilization and mobile home owner protection ordinance, the mobile home has to be located in the unincorporated area of LA County. It has to be constructed before January 1st of 1990, and it has to be either under a short-term lease, such as a month-to-month lease, or a long-term lease that was entered into after February 13th of 2020. If the mobile home is currently under a long-term lease that is still in effect and was entered into prior to February 13th, 2020, unfortunately, it is excluded from our protections. This is going to expire, however, this exemption will expire on January 1st of 2025. Next slide. Okay, permitted rent increases for mobile homes under our ordinance. Rent increases will also be capped at 3% for the remainder of the year, 5% for luxury units. A rent increase is also allowed only once in a 12-month period. Rent banking is not allowed. The absolute cap is 8%, even if the consumer price index goes above that. For mobile homes, this is in line with California state requirements. A minimum 90-day written notice is required prior to the increase going into effect. And when a mobile home is sold or the title changes or made vacant, there is actually limits on rent increases. There may not be an allowable increase if it was transferred to a current occupant, a qualified relative, or if there was already a rent increase in the previous 12 months. If it doesn't meet one of our limiting qualifications, then the rent may be increased up to 10% following the change. Next slide. So our ordinance does not regulate evictions, but this is just to give you an idea of what types of evictions a mobile home owner may face. So it may be not complying with a government order, nuisance, illegal activity, violation of the mobile homes parks rules, non-payment of rent, utilities, or reasonable incidental charges. The mobile home owner, I should say, has to pay within 5 days. The park owner needs to give a 3-day notice after the 5th day. And more than 3 late payments, the park owner may also be able to evict based on that. If the mobile home park is condemned, that may also be a reason, or a change in the use of the mobile home park. Next slide. Okay, now this is a slide referring to a commission that oversees some of the decisions that the department makes. So it's called the Rental Housing Oversight Commission, or we refer to it as the RHOC, and it makes determinations and resolves appeals of decisions made by the county. I should have mentioned this in our slide regarding allowable rent increases. Now that I've covered them for both mobile homes and other rental units, I want to let people know, what do I do in the event that I receive an increase that is unlawful, that is contrary to the regulations set forth by the county? Well, first and foremost, you want to try and inform your landlord of the requirements that the county has, because 99% of the time, it's just a simple mistake in which they don't understand which of the complicated rules apply to their rental dwelling. So try to inform them, try to get them to call the county. If they don't take action, then gather as much supporting evidence, create a timeline of the payments that you made, and contact our department. You can file what's called an application for rent adjustment. This is for mobile homeowners as well, where our department will review and determine what the allowable rent increase should be, what the rate of rent should be, and if any overpayments of rent should be returned to the county. As part of that process, once we make our determination, the parties are allowed to appeal. So that's where it would get to something like the Rental Housing Oversight Commission. They make determinations and resolve appeals of decisions made by the county. They safeguard tenants and mobile homeowners from rent increases that are inconsistent with the county code. They ensure that landlords and mobile home park owners receive a fair return on their properties. And they oversee mobile home park closures, conversions, and changes of use by requiring relocation impact reports before those can proceed. Next slide. All right, I'm going to pass it back to Scott, who's going to go over some additional resources.
Okay, thank you very much, George. Very informative. A lot of information in there. So yeah, we did want to talk about some available resources. If we could do the next slide, please. Okay, so we get a lot of inquiries about rent relief. We do want to make folks aware that there has been some money allocated for rent relief for LA County. These programs are still being developed. There is no financial assistance being offered currently. We suspect that over the coming months, we'll have more information. And as we have more information about financial assistance and rent relief, we will be posting that information on our website, on the DCBA website. These rent relief programs, just really high level, they are geared towards small landlords and small landlords that have non-paying tenants. There are going to be certain eligibility requirements, but those will be forthcoming. So right now, and I'll cover this in a minute, there's really only rent relief available through our program Stay Housed LA. But over the coming few months, please keep an eye on our website regarding financial relief and rental assistance for landlords that have tenants who owe back rent. You know, once these programs are up and running, we will have further information. In addition to what we do here in the Housing and Tenant Protection Division, our department does have other capabilities and other focuses. And one of those services that we provide is our dispute resolution services. This is also referred to as mediation. This is a program, it's a voluntary program. It's confidential. If both parties, say landlords and tenants, are willing to work with a neutral third party, they can utilize these services for free and see if they can avoid having to go to court to resolve the issue. So I wanted to mention that. And then can we do the next slide, please? And as I mentioned, we do have a program, Stay Housed LA County. It's a partnership between the County of LA and tenant-led community organizations within the county, and also legal service providers that can provide tenants with information, with services, resources, and support tenants might need to exercise their rights so that they can potentially remain safely in their homes. The Stay Housed LA County program does offer certain limited and full scope legal representation. They do offer rental assistance for income eligible tenants for up to 9 months or $20,000. The program offers virtual Know Your Rights workshops, which are very valuable and have a lot of good information for tenants. So we strongly encourage you to visit the Stay Housed LA County website and get yourself signed up for one of their webinars to learn more information about your rights. The Stay Housed LA County program also provides referrals to financial, legal, and other potential resources for tenants. Next slide, please. Eligibility requirements for Stay Housed LA County. Tenant does have to be a renter in LA County. A tenant to be eligible would have to have received a notice of termination of their tenancy or an unlawful detainer court summons, otherwise known as an eviction. Tenants would have to meet certain income eligibility requirements as well. For the Know Your Rights workshops, there is no income limit. However, for legal representation, there is both for limited scope and for full scope legal representation. There's up to an 80% area median income requirement for tenants. So we just wanted to mention that. Next slide, please. In order to contact Stay Housed LA, you can call them at the number listed on this slide. You can also visit their website. As I mentioned, you can sign up for webinars there. The web address is listed here on this slide as well. And then you can, of course, follow them on social media. Next slide, please.
Okay, so again, we do apologize that we were unable to get to everybody's questions. Lots of questions in the chat. Again, we have our contact information posted on the slide, along with helpful links that should address most of the questions coming in. If you do not want to wait in queue for a representative, again, please visit dcba.lacounty.gov and click on the schedule a phone appointment link, and you'll be able to schedule a dedicated time to have one of our counselors reach out. Okay, thank you everyone for joining us today. I hope the information provided to you all was helpful. And again, we look forward to getting your questions and calls so that we can further assist you. Thank you all.